So, welcome back to episode 4 and 5 of the property series. Today, we're talking about buying an RDP house. We're also talking about the things that you need to look out for if you're buying a property that's owned by a company or that's owned by a trust. So, today we're combining episode 4 and 5 because we know we have delayed putting out videos in this regard. So, we'd rather do it in one go so that everybody gets the benefit of both episodes in this one video, and so that we can also move ahead to other things. Okay, so without further ado, let's get into the conversation. But before we do so, let me introduce myself. My name is Yolanda Mnyengeza, and I'm an attorney and a director at Mnyengeza Attorneys, and we are based in Johannesburg. So let's get to the conversation. So let's talk about an RDP house. As a buyer, what are the things that you need to look out for? What are the formalities that need to be complied with? And thirdly, what are the documents that are required in order for this type of transaction to be a success? Now, first thing that we need to understand about an RDP house is that the people that own these properties were benefactors of the government. The government gave them those houses because they needed them and they could not afford to buy their own. And so as part of that initiative, the government puts in conditions as to how those people can deal with those properties. For example, once someone has received this property, they don't have the right to sell it before the expiration of the 8-year period. However, a lot of people tend to want to do this, and there's a number of reasons why people want to do this. Some, it's because of health issues or whatever the case is. Now, if people want to do so, because there is this condition that they're not supposed to, they need to get permission from the government themselves, which means what? Means formality number one that needs to be complied with is that the seller needs to get the consent of the government before they even try to take money from you or before you even pay them. Otherwise, if they don't get that consent, it means that you might actually lose your money. So you want to make sure that this first formality is complied with. Now, if they have complied with this, then at least you're safe. You can move on with the transaction and look at the documents that need to be considered and also the things that you need to look out for. So what's the first thing that you want to do when you're about to purchase an RDP house? Now, the first thing that I would advise you to do is to establish first how long have they had this property, so that you can know whether or not they need to comply with the issue of consent, that they need to apply for it and get it. If they've had it for more than 8 years, it's not a problem. That particular condition, is not going to need to be complied with because they've had it for more than 8 years. But if they had it or have had this house for less than 8 years, then they need to apply to get the consent. So you don't do anything before they do so. Now, the second thing that needs to be done, should this consent now be attained, it's here, it exists. Now we need to then move on and establish what's the marital status of this person that's selling this house to you. Are they married? How are they married? If they are married in community of property, request that the other spouse also join as part of this sale, because even if the other spouse is not registered, if they are married in community of property, the other spouse also has to be a part and parcel of this transaction. So make sure that they invite their own spouses. That's the other formality. And the second one is make sure that the contract is drafted. So you guys need to go to a lawyer. You need to go to a lawyer who's going to draft for you, or an attorney, so to speak, who's going to draft for you the contract that you guys need to sign, which is the deed of sale contract. So you need to go to that person so that you guys can have a discussion. Okay, and the third or the final formality that needs to be complied with here is that the documentation that is necessary needs to have been collected so that this transaction can be a success. So what are these documents that need to be collected? Let's move on to that particular aspect. Let's talk about the documentation that's required for such a transaction. Number one, the title deed is the most important document that also must be here as part of this transaction. Now, any property cannot be transferred without a title deed, so it's important to make sure that even when you're having the initial conversation with the seller to establish whether or not, in addition to the consent, whether or not they do have a title deed, an original title deed. A copy doesn't work, because if they don't have the original title deed, it means that they have to apply for a new one at the deeds office. So make sure that they have this. And secondly, the ID copies of the people that are going to be part of this transaction. Who are these people? It's going to be you and the seller. If the seller is married, also his or her spouse. So all of the ID documents of the people that are part and parcel of this transaction need to provide their ID copies. The third document that needs to be here is the rates letter. So we need to know exactly where exactly the rates are. So the rates letter is needed in this particular transaction. And the fourth thing that's required, if the seller is actually married and is married in community of property, they need to provide you with a copy of their marriage certificate. If the seller is saying that he or she got divorced from the spouse, the divorce decree must also be a part of this transaction, because you want to make sure that every detail and document is here to ensure that this becomes a successful transaction that doesn't create unnecessary problems for you in the future. So let's move on to the things that you should probably take note of. Now, one of the things that you want to take note of is actually the property condition. You want to go see the property. You want to go see what it looks like. The reason why you want to do this is because you want to make sure that you understand what the issues are with this property. Does it have any damage? If it does, so that you can be able to establish between you and the seller who's going to cover, the damage here, who's going to fix it. If it's damage that's on the door, things that you can see, who's going to be responsible for it and how is it going to be dealt with, so that you know exactly what you're getting into. The reason why I suggest people do this is because often people get into these transactions and buy these houses and then later on say, you know what, I noted that the house had this and so the money that I paid to the seller was not reasonable. I want them to pay for the things that I've fixed. But if you have seen those things, it's not reasonable for you to now want the seller to pay for them. It's only when you did not see those things, you could not see them with your naked eye, they were hidden, could you then argue? So people often want to use this to try and get more money from a seller. Unfortunately, you will not be able to get more money if you overlook talking about the things that you see. If you see a damage, talk about it to them so that they know where exactly you stand. And if you need to include it in the contract, then so that you guys can include it in the contract or negotiate something pertaining to those damages. Now, the second thing that you want to look out for is how much this particular property owes to the local council. This is also something people tend to overlook, and they make payment or towards the purchase price before they actually understand what the local council debt is looking like. So this is actually a risk on the part of the buyer, because properties cannot be transferred when there is money outstanding that's owed to the local council. That debt needs to be cleared because the new owner has to take up this debt at a zero balance. And so if there is a lot of money owing and the seller doesn't have money, and you only find out after you've transferred the money to the seller, it could be a problem for you. So you want to understand exactly where the rates are, how much is owed to the local council, and so that you can have a discussion with the seller how they're actually going to settle this and how it's actually going to work between the two of you, so that this is not a hindrance when it comes to the transaction aspect. And the last thing that you also want to have a look at or consider is who is living on the property. Is the property, is the owner the one living on the property, which is the seller, or is there someone else that's living on the property? Very important. The reason why this is important, because you want to make sure that when you buy this property, there isn't going to be any issues when you have to take possession of it. So normally when it's not the seller that's living there, it may be a bit difficult to remove people out of the property, even with a lawful eviction being granted. So you want to make sure that this is actually settled between you and the seller. So between you and the seller, as you're having that conversation, you want this to be settled before you actually get into this transaction. This will save you a lot, because a lot of people have actually gotten into such transactions without thinking about this, and have ended up having to pay additional fees to try and evict people out of those properties. And in addition to this, even with a lawful eviction, sometimes the people that are in possession of those properties refuse to live. So you need to just assess everything about the property that you want to buy. So don't just look at the fact that you want this property and the purchase price is looking good. Have a look at everything, the overall aspects of this particular property, what affects it, so that you can make the best decision for yourself and avoid any issues in the future. Let's talk about you buying a property that's owned by a company, or you buying a property that's currently owned by a trust. So now let's move ahead to when you want to buy a property that's owned by a company or a trust. So the first thing that you want to establish when you want to transact with an entity is that you want to make sure the person that you're going to be dealing with, that's going to be coming to you on behalf of the entity, actually has the authority coming from the entity, and they also have the authority to sign certain documents so that this transaction can be a success. So how does this normally happen? Now, in the case of a company, what needs to happen once a company has decided as on their own that they want to sell a certain property that they have, a board resolution will have to be signed and drafted, wherein they actually state that they want to sell a property and that they are appointing a certain person as the one who should be who should initiate this transaction and who's also going to be signing this document. And so that person that's coming to you must be the one who is actually authorized in terms of that particular resolution. So it must appoint him as such a person, and where necessary also get a letter of appointment from the company so that you can transact with him or her. Otherwise, you will be in trouble should you not do this. This is even necessary in a situation where a person even started that company on their own, or they are the sole board member or shareholder in that particular company. Because the thing is this, even though I may open and set up a company is a separate entity, it's a separate person altogether. So the fact that I opened the company doesn't mean that it's me or it's an extension of me personally. It's a company that exists on its own. And so a company, every transaction that it does is done through a person. And so authority must always come from the company itself. In order for such a person to actually transact with you, it's not enough for them to say, this is my company. No, they should, on their own, draft a resolution to state that they're appointing themselves, number one, and number two, that they're wanting to sell a property. And in addition to this, also they must appoint themselves as the person that's going to be responsible for signing the necessary documents. Then there will be a necessary authorization coming from the company. Then they can come and deal with you. Because if you don't do this and you just transact with the person on the basis that, you know what, they're the ones that set up this company, this could actually backfire because it could mean that in actual fact this whole transaction was not a lawful transaction. So you want to stay away from such things. In such transaction, I always advise that you use your own attorney to help you with this so that you don't make mistakes. You know, there's a lot that is contained in such transactions, and so it's better that you don't do it on your own. You have your attorney there with you to advise you on this. Okay, it's the same when you're buying property that's owned by a trust. You want to make sure that the person that's transacting with you, who is the trustee, is the one that actually has the necessary authority. The trust allows him or her to actually transact with you or sell that property so that you don't have issues in the future. Once you've got such authorizations, once you've got this necessary appointment coming from the trust itself, then you can deal with such person. Then you can allow them to talk to you and have a discussion on the aspect of selling this whole property or the whole property transaction. Now, in addition to this, it's normally you just making sure that the normal documents are obtained. For instance, the title deed, the rates letters, the contract is drafted in accordance, and other things that could necessarily be necessary in this part of the transaction. And the third thing, you also want to have a look at the necessary things that I often say you need to look out for. For instance, the condition of this property. Go and assess it, have a look at it. What does it look like? And secondly, you want to have a look at the rates letter. You want to have a look at the levies. Should this property actually be in a sectional title? What's the situation there? And thirdly, you want to have a look at or establish who is residing on this property, who has possession currently. How is this person actually going to vacate this property? If they don't want to vacate, who's going to be responsible for evicting them, so that you can get to the bottom of all of these things. So that in essence, is what you need to look out for when you're about to buy a property out of an entity, so that you make sure that you are in good terms. But I repeat, do not do this alone, because these things get technical. So if you're not well versed in this aspect, you might miss out on other things, because like I said, some of the things that I mentioned here might probably miss out on the most technical things that need to be included. I'm just giving you an overall look at some of the things that you need to know and be aware of and actually take into account. So this brings us to the end of our discussion today. Like I always say, if this was helpful to you, just make sure you also share it to other people, so that they also can get the education and the empowerment that you have also received, because we want everybody to be empowered. So like, subscribe, come back, because we have more content to give to you. So let's meet next time when we have something else to discuss. Again, my name is Yolanda Myengeza, and I'm an attorney and a director at Myengeza Attorneys. Let's see you next time. Have a great weekend.